Good morning. We are in Senate Judiciary. It's January 9th. We have the Defender General here with us to share their perspective and thoughts on S-178.
I'm happy. And thank you for having me in on 117. Let me preface this subject of speed trial with kind of where we are with speed trial. Probably every school kid knows, and I'm sure everybody in this room knows, somebody charged with a crime has a constitutional right to a speedy trial. The right already exists. And it, as a part of a very fundamental building block of the criminal justice system. Over the years, however, the definition, what adds up to a speedy trial, has been eroded to such a degree that effectively in no case does somebody actually have a right to a speedy trial. Even when we were, I go back to the pandemic and the courts effectively closed down for all trials for a 3-year period. And at the beginning of it, I was asked to comment in the press about this, what about speedy trial? Like, well, there's nothing in the Constitution that says your constitutional rights go away during a pandemic. So we must have constitutional right to a speedy trial because the courts are the state, and state's not just state's attorneys, it's the Department of Mental Health, it's the executive branch, it's us. So I would, and at the time I said I would anticipate that for clients who demand it during the pandemic, that we would be able to actually have trials. As you might expect, they weren't happening. Motions were filed. It was ended up litigated, and effectively the results were that basically the pandemic excuses us from having speedy trial. And I was kind of stunned by that. We basically, not only did we suspend trials, we suspended all kinds of constitutional issues during the pandemic. I guess if things get bad enough or whatever, then we don't have a constitution anymore relative to certain issues. And speedy trial is like one of the things of the many things that could go wrong. It's it's important. What I do is fundamental to what we do. But what has kind of happened as the courts have excused away reasons why speedy trial shouldn't happen is that the right is effectively been eroded to almost nothing. The last case that I remember being, fundamentally a serious case that was impacted by speedy trial was the Bruin case out of Bennington. At the very beginning of my tenure as Defender General, this is probably 20 years ago now, and I've been in the job about my 25th year. But this was a client who, for various reasons, had dismissed either fired his lawyer or had conflicts with the lawyer, actual ethical conflicts arising as a result of professional responsibility, and had gone through a number of them. And it was a serious case, and I had I could get him a lawyer, but it was going to take him a period of months to be able to get to the case. And ultimately the Supreme Court said, no, that's a violation of the speedy trial rights, not because of anything that like the court didn't get to the case or the prosecutor couldn't get to the case. The irony of this is as state as you can imagine, but it's because the defense system was unable, after by the time he was down to sixth lawyer, get a lawyer for the case, which is not usually the way any of this works. And the case basically said, well, the system is the state, and that includes the public defense system. And the case was ultimately dismissed. It actually went up to the U.S. Supreme Court, and then back. U.S. Supreme Court said there wasn't a speedy trial violation, and then it was re-argued at the Vermont Supreme Court, and the Vermont Supreme Court found that it was a speedy trial violation under the Vermont Constitution, not under the U.S. Constitution. So then the U.S. Supreme Court decision didn't have any applicability to the case. It was fun times doing this on the case. In any event, so I applaud the effort for sure to put some teeth behind what you'd think would have teeth already, being a constitutional right to a speedy trial. That some of the details, we could just, argue about some of those. But I do think something needs to be done, because clients routinely say, I want speedy trial. And then you'd have to explain to them all the reasons why. Well, you can't file motions to suppress in a speedy trial situation because those will get counted against you. Time-wise, you can't. There are all of the various things why you can't get a speedy trial. And a bunch of that's actually incorporated legitimately into this bill. But then there are lots of other reasons, why cases are not really subject to speedy trial. It'd be great to have some actually hard and fast rules or a statute that defines what these are, so that defendants and both prosecutors and defendants have something that they can. I'm just getting a glare out of the outside. So obviously I went through the bill. I looked at all the provisions. I want to direct your attention over to page 3, line 13, 14. Delay resulting from examination of the defendant and hearing on defendant's mental competency or physical incapacity. The only thing I agree with this is fine conceptually, but this is one of those areas that the state in general is falling short on, because it can sometimes take us, not even sometimes, oftentimes take as long as 6 months from the time an evaluation is ordered for that evaluation.
Yeah, can I just interrupt real quick? When you're saying the state, are you referring to the prosecution or the Department of Mental Health or agency?
I'm not talking about the state's attorneys. I'm talking about Department of Mental Health. Any of those that need to provide the evaluations for the benefit of the justice system, whether it's mental or physical, traumatic brain injury or not the mental illness issues. But it can take a really long time. And, this is over a period of time with the washing away of the state hospital and the effect that we don't really have a state hospital at this point, and the lack of experts that are available to provide the initial competency evaluation. This is a state function that we need to get better at. What ends up happening with these folks is they end up on conditions of release for months and months or longer, both waiting evaluations, waiting for them to take place, and then to get the actual results of the evaluations. And this boils down to really a resource failure on the part of the state. And so, I don't know if the right thing to do is to put a cap of, you got to get these done in 90 days or 120 days or something. But the delay resulting from getting an examination should not be a delay that is attributable to the defendant once it gets beyond a certain point. The unfortunate thing is, and this is, we see this in a lot of the cases that were up in Burlington with the special docket that was established up there. These folks get labeled as treatment resistant, and really what they are is people who are unable on their own to access treatment while their case is pending. And I talked about this at length yesterday in House Corrections and Institutions. But these are people who they go to court, they end up on conditions of release. There may be a pending evaluation that's going to come at some point when somebody figures out when that's going to be. In the meantime, they start picking up other charges for violation of conditions of release along the way. And the longer they stay out, the more charges they pick up. This delay, to me, is not something that really should be attributed. The problems arising from that should not be attributed to the defendant. As an aside, but related, I wanted to say that in that docket up in Burlington, one of the things that we would have had similar results no matter how many times you bring somebody to court quickly. But even though we didn't get more money, I designated $47,500 for the 3-month period to hire a company called Therapeutic Works up in Burlington that basically would fill the gap between the court order and the people who in AHS, Department of Mental Health, or whatever provider was up there. We were sitting there, like a catcher waiting for a pitch to come in. And what Therapeutic Works, they're all licensed psychotherapists. They can do all the same evaluation screenings and that sort of thing that mental health and AHS was doing, or the Howard Center and the like. But what they would do if there was an order is they would connect the two. So if a client got ordered on a condition of release to go from the court, they would make sure that person got from wherever they live, if they had a place to live, or from the court to Williston to get their evaluation. They also had a downtown place in Burlington so that they weren't hanging out in doorways or going into stores and annoying people or whatever. And they had a drop-in. You could drop in, you could get soup or coffee or a place to sit where it was warm when it's 10 degrees, that sort of thing. So what it was doing is eliminating violations during this period, and it was connecting a specific individual with the place where they were supposed to go to be evaluated or serviced. Late in these cases, and the right to get their cases resolved quickly is not just about getting it done quickly. It's about preventing other crimes and other violations of conditions of release. So these people who have been labeled as treatment resistant are not always treatment resistant, but they literally can't figure out, how do I get from, Cherry Street to Williston when I don't have any transportation? I might be mentally ill, I might have a substance issue, I might have both. I have no transportation. I might not have a place to live. I don't have a job. I don't, they got all kinds of things going on where they are just individually are willing, but they are not individually capable of doing what the court ordered. And so this connector, this social work connector, that we put in place because of this docket being consolidated, prevented a lot of violations during the period of time while it's running. Her point, though, relative to speedy trial is the quicker we can get these things resolved, the less you're going to have any of that stuff going on, because now, in theory, we're going to, if we can social work them appropriately after the fact, we're going to get them a quicker resolution of their case. Now, there's also those who are going to be found not competent, and we did that during this period of time. The system did that, not the Lieutenant General's office. So we did our part, but you are also there's some people who legitimately need trials. They just need to get to trial, and those people got on a trial list. I don't know if there were any trials during this period of time up in Chittenden as a result of this docket, but there at least now we've identified those. And then there are lots and lots of dismissals because the state realizes they don't have the evidence that they need to prove their case, which is also another issue like with speedy trials. The longer these things drag out, is the benefit, even though clearly state's attorneys would not like to have, I don't like to generalize because there are some who might think otherwise. So, deference to them, I make this generalized statement, which is always a dangerous thing to do. But generally, state's attorneys don't want to dismiss cases. They don't have to. But it's in the state's interest as well to get a case to trial quicker rather than not, because the witnesses are around. They haven't disappeared. They haven't changed their mind. They haven't done all the things that witnesses do in cases. When you bring a case to trial 2.5 years later on a misdemeanor, or a felony for that matter. So there's a benefit to both the state prosecution side and the defense to bring cases to trial or resolution as soon as possible.
Matt, thanks. Can I ask you about a specific piece on page 2? We had Judge Donay and some other witnesses talking about this, the state's attorneys, prosecutors. So it begins by saying that someone can
What line are you on?
I'm on 1 on page 2. Prosecutor shall respond to a motion filed pursuant to subsections within 14 days. Court may set the matter for a hearing. And it seems to me this is the main action of the bill, is to create this opportunity for the case to be dismissed if it meets all these criteria. The knock on that the state's attorneys had was that it was going to actually delay things or make the backlog worse because it increased the number of hearings, etc., the amount of paperwork that they're required to do. What's your take on that section?
I've kind of heard this argument before when we were dealing with motions for a deferred sentence over the objection of the state's attorneys. The argument was that they were going to get flooded with defense motions for deferred sentences over the objection of the state's attorney, which I said at the time, that's not going to happen because you're only going to do it in appropriate cases. And my feeling is it's the same thing. If a client demands a speedy trial and then doesn't get it, and doesn't fit any of the criteria that extend things and exclude things, don't apply, you're going to get a motion. There are a lot of things even in this bill that tries to set it up that would mitigate against filing motions for speedy trial, because you do have to do discovery and you do have to file motions to suppress it. Like, now I know personally, there are ways around some of that stuff, that we may well train on. I mean, you don't have to file a pretrial motion for, suppression, for example, based on a illegal search or whatever. You can actually file it at trial, and you have the trial and the suppression at the same time. And in fact, even if you lose, say you filed a pre-trial, you can renew the exact same motion at the beginning of trial and retry the issue of suppression. But we don't have time for that either. You know what I mean? What they're worried about, there's going to be all these motions and we don't have time to respond. We don't have time to file the motions when they're frivolous. We don't have time to file them when they don't fit the other criteria. So I don't think that it is going to be like an overwhelming thing. You know, we can argue about, you know, do you get 14 days to respond? Do you get 30? Or some of the, you know, details to make it more palatable, or the, you know, whether the state even has to respond and to the motion. They could either just say, you know, we agree or we don't, and then you're going to have a hearing at some point, and you're going to consider all these criteria, and a judge is going to have to make findings relative to, and then it puts no burden on the state's attorney except for to say yes or no. The bottom line is that this, you know, as I said at the beginning, this concept of speedy trial that we have in the Constitution has been watered down to where it basically doesn't exist, except for in the most extraordinary circumstances in the system. You know, like I said, our clients know that there's a thing for speedy trial. Then you have to explain them all the reasons why. Well, you really don't. This would at least give them, you know, say, hey, look, these are the times you can do it. And what the statute says, it kind of redefines the issue, rather than us just saying that's a waste of time because we don't even file motions to dismiss for speedy trial anymore because it's a waste of time.
Yeah. Judge Zoning was also saying that, or maybe I'm remembering wrong, but I thought he said that defendants already had the right to file what this bill seems to give them the right. You know, on page 1, a defendant charged with a nonviolent misdemeanor or nonviolent felony may move for dismissal if it is not commenced. I don't know the law well enough to know if
it is not commenced within a year.
Right.
Yeah.
Is that currently, could they file?
Yeah.
Yeah.
Sure. That's not wrong.
Okay.
The problem is that the exceptions have swallowed the rule.
Yeah.
All the reasons why you aren't going to get a dismiss. Yeah. And no, he's not wrong. That's the whole, it comes down to the case. Absolutely, a speedy trial right exists in the Constitution.
Mm-hmm.
But
is the idea here, do you think that this would signal to prosecutors and judges that 1 and 2 years are reasonable frameworks that they should?
Yeah, I think so.
Matt, if I can, I'm sorry, did you have more of a response?
Not to that question.
So what I'm also trying to get at here that I think and hope is different than what we currently have as a remedy is if a motion is filed by the defense, they're not necessarily going through all the interest of justice elements. But when it goes beyond that timeline of the 1 or 2 years, then that burden flips to the state and then requires the state to say, all right, here's why we're going to justify in this motion that this case needs to stay off calendar. And here are the reasons why.
Yeah, I will say that that could be said better in the bill. I mean, just directly, you know, the state shall now have the burden of, by, you know, you might even put a standard, you know, must prove by a preponderance that, you know, whatever the criteria you want to put are, you know, just to be clear about that. I've always been kind of flummoxed by the whole speedy trial issue because I've literally never gotten anywhere with it ever. Didn't matter how old the case was. I think that, you know, we do have to, and I've made some suggestions to the some legislators, about, we have people who charged with misdemeanors where the maximum sentence is 2 years. They've been on conditions of release, haven't violated them. They've been on, and they're waiting a trial, and it's been 2.5 years. They've effectively been on probation for longer than they would have been if they just pleaded the case day one, subject to criminal liability for violating these conditions of release, and still you can't get anywhere with speed trial. So I've often thought that, if you're on conditions of release, and I've said this, for 2 years, for a misdemeanor that has a 2-year max, like that's what the problem is. Case should just go away anyway. We've already gotten anything you're going to get. Like, sure, very few misdemeanor cases you're going to get jail on, except for the ones that have mandatory jail. Keep trying to get rid of those. The DUI keeps changing so that it's going to be 2 years or it's X amount. After whatever it ends up being. And honestly, I used to hundreds and hundreds of DUIs in my private practice so long ago now, but it's changed so many times. I don't even remember now how many hours it is that you're supposed to send, because nobody really wants anybody to go to jail on. We don't want to put those people in jail because we got more serious cases to go to jail. In any event, this might help with some of that, at least sends the message that the legislature has an intent that speedy trial means something. I wanted to, if you don't mind, you have
one moment, Senator. Yes, please.
Yeah, no, I wanted to circle back to that because I've actually suggested this a couple of times in this committee, the idea that you're pointing to of cases that have lingered longer than the maximum sentence, particularly non-violent cases, just being dismissed. And I wonder, would that be legislation that we would need to work on, or would that be something that courts could just do? Or I guess state's attorney.
I've always thought that this is part of what happened up in Franklin County shortly after the pandemic, and they got rid of hundreds of cases with the agreement of the state's attorney and the defense up there. Cases just like this. Other state's attorneys were like, we're not doing that. So that is, it is doable by agreement, clearly. I've always believed the court could do it under Rule 48, but judges are reluctant to dismiss hundreds of cases that fall under this category because they don't want the heat. I don't necessarily blame them. If the legislature did something that said that, if you've been on conditions of release without a violation for more than the length of the sentence, then
It shall be
it could be dismissed. You could do that.
Okay.
It's like a speedy trial. It's akin to it, but it's not the same. It does give incentive to defendants to hang in there and not violate. They're the ones that we have difficulty with are significant numbers, but not. I don't even want to say like the majority. Everybody thinks that everybody in the criminal justice system needs treatment. That's not true. They don't. Sometimes they need to just be left alone so they can get past whatever they did or didn't do. Hence administrative probation. In any event, and some people don't even need to be on probation. They just need to be, not looked at all the time. In any event, this would give incentive for everybody to get cases resolved before the 2 years. And it could clean up some amount of the backlog. I don't want to pretend that it would do all of it, because they're going to be, you're going to have people who, they have a felony retail theft or a felony unlawful trespass or unlawful mischief, and then they'll have 8 misdemeanors. And those people under that scenario, because there are a couple of felonies, even though the difference between the felony and the misdemeanor is, one person had a $700 broken window, and the other person had a $901 broken window, one's a misdemeanor, one's a felony. You know, I mean, we could always classify certain non-violent felonies that are based on value or that kind of thing. That's part of the group too. But there are a lot of people who have what it's all general scheme of things, but minor felonies that could be included in something like that. And I'm just thinking about like, how do we get out of this backlog issue? Even though the court, like in the last quarter, we made a lot of progress on the backlog. During that same quarter, we saw like a 30-something, it was like a 39% increase in caseload in Chittenden County alone. Statewide, it was over 15%. How do you, those aren't in the backlog, those are new cases. So how do we like, you know, they're going to be a backlog. It's just, we aren't there yet with them because they aren't old enough. So, you know, I'd like to get us back to where we were in the few years before the pandemic.
Do you have a sense of, this may be a better question for the judiciary, and I think we're probably going to get this information, but do you have a sense of how much of the backlog doing something like that dismissal protocol we just talked about would clear?
I can definitely find it. I have an estimation because I've looked at this really since the pandemic dragged things out. Like I thought, a lot of us, even at the beginning, were like, "Oh, this is going to be a month and we'll be out of this," right? And then it was 6 months. But once we started going over a year, I started looking at this periodically, and the amount that is like in the backlog itself, I think we're probably talking 20%.
That's pretty significant.
Well, yeah, I mean, we do 22,000 cases a year, and that includes all the felonies, but there's a lot of misdemeanors. It would do a chunk of stuff. You know, some counties, it's all charging, part of it's charging decisions, you know. And so some charge a lot of misdemeanors. You know, I've heard that you know, the response might be that where the prosecution has a choice to choose a misdemeanor or a felony, if something like this went through, they would just choose to charge felonies and then settle for misdemeanors as opposed to charging misdemeanors. You know, lawyers are a pain in the butt. We can figure out ways around everything. I literally remember the first time and I wasn't defender general at the time, but I testified in front of the CSC here. Called me, I don't remember what the bill was. And I remember saying at the end of my testimony was that, you know, I wasn't keen on whatever was going on, but I said that even if you pass this, I've kind of already figured out a way around whatever you're going to do. And he laughs as he would usually at me, and just said, "You damn lawyers always, you know, always screwing with everything we're trying to do." And like, yeah, well, you know, it comes with the territory, I guess. And but that's, you know, I could see if I were a prosecutor how I might, if I didn't like the way this was going, how I might respond to it, and that wouldn't be a good thing either. So
I do, just something you mentioned, I have an Excel spreadsheet that I received in December when I first started this bill that can answer a lot of your questions. I'll share it with the whole
is
committee.
that from the entire judiciary?
Yes.
Oh,
Yeah,
good.
so you can sort through, you know, what cases are inactive due to competency evals and take those out. But I'll share it when it's useful for this. Yeah, another question.
I did, and that was, you know, to your point that, you know, if something like that dismissal protocol were to go into effect, prosecutors might charge with felonies. If we included the sort of non-violent
Yes,
felonies, wouldn't
Where
that
they
sort of
could.
account for that?
if you included, it might with some, for
Okay.
sure. Yeah. You know, the thing about, there's a lot of like minor assault looking type stuff. Things can be anything from disorderly conduct to aggravated assault in the exact same set of facts, and it's just how you describe it. They, you know, can be, and sometimes it's mutual affray, sometimes it's, you know, simple assault, sometimes, you know, it's how you write the affidavit, how you decide to present it, and you can get by probable cause pretty easy, and now that's where the leverage comes. And I guess all I'm saying is like some stuff that is violent, is not really violent. And some stuff that looks like a felony isn't. There's also stuff that is misdemeanor, but it's much more serious than it appears on paper. We defense lawyers depend on that in the resolution of cases. To be perfectly honest, I always like to say we're ready, willing, and able to try cases when they come up, but nobody really wants to try a case if they can avoid it. It's a lot of time, effort, money.
Matt, there's two questions. One, going back to something you mentioned a few minutes ago, you had mentioned that this could create an incentive for everybody to try and resolve a case before the 1 to 2 year timeline. Why would it create an incentive for the defense to resolve before the 1 or 2 year timeline rather than just trying to wait out the clock?
I believe one of the very interesting misconceptions in the world is defense, and I hear this, I've heard the governor's counsel talk about this, is that defense just loves to delay everything. Coming from someone who's never a defense lawyer, I guess I could see point of view of Jay Johnson saying that. It's totally the opposite. Defense lawyers want to resolve cases as quickly as they possibly can under almost every circumstance, because they got 100 other cases that they have to deal with. Get this one off by plate. There's almost never an incentive to delay cases for years. It doesn't make any sense from a case management or from a business management standpoint. One of the hard things now about doing like the video and regional arraignments that we do, we can't resolve any cases at arraignment. When I was first teaching, I would go around the state. I'm from the Rutland County area, so I went into the Rutland office and I went to arraignment day, and we were able to resolve 50% of the cases that came in on arraignment because we were physically meeting with the clients, talking with them, and we just let the court know, yeah, we got a deal, and let's do the arraignments, and we'll have this guy wait around, and now we'll resolve it. So if you had 10 people in on arraignment, we might resolve 5 of the cases before. That doesn't happen now because you never see the client, you don't know who they are, you don't get to talk to them, and the like. So really the incentive, just as a case management standpoint, is always to resolve the case if the client wants to resolve the case. And some of them, that's all they really want to do. It's just we don't have the infrastructure anymore to do that because the clients, the ones who are lodging, they're not transported anymore. They don't come to court. So you never meet them until 90 days after the arraignment. Then you don't know who they are or where they live or, any of that stuff because you never get to meet with them. But one of the things that would resolve some of the speedy trial issues, backlog issues and the like, if we'd actually had clients coming to court where we could resolve the case that they got. But I don't think that purposeful delay is a general strategy, number one, that is employed, and number two, that works even if you try. So
it's also against the rules of professional conduct.
It's against like the very first rule. It doesn't, by the way, the rules don't look, they used to say that you have to zealously represent your client. They don't say zealous. It now says expeditious. And then it's subsumed in the other rules and things about, they don't use zealousness anymore because it led to bad behavior. But it's not what the rules say. So, do some lawyers maybe think that's a good way to go? Maybe they do. I don't think they're too bright if that's what they think and do. It's not good. It's not good business, not good process.
The other second question I had for you was regarding the definition of violent. I figured this might be an issue because some things that are violent well, I'll just leave it there for that. But do you have any suggestions as to how we can further clarify or define what a violent offense is in this statute?
If there are ones that you want to include specifically, just listen. You know, just listen. It's the only way rather than trying to figure out what's violent for purposes of speedy trial and this statute. Now, speedy trial is still going to exist for everything in theory. I mean, you could get a murder case dismissed for speedy trial violations, potentially, in theory. And that, you know, that was going to be one of my suggestions is to add to the statutes, you know, notwithstanding everything that's here, this doesn't abrogate any constitutional rights to speedy trial that pre-existed. These specific requirements in statute, I would add something like that. But if there's a list of crimes that you have in mind that you want to be subject to this particular statute, then list them. Otherwise, we're going to be arguing at the Supreme Court about what you meant by violent or non-violent. You know, I had a couple of other little things here that I wanted to just bring up.
Before that, the committee, any other questions?
I do, but in the interest of time, I don't got floor 11:30 here. So I got a couple of questions. Is it my understanding there is no definition of a speedy trial in Vermont or something like it?
It's all been defined by various individual cases. And over a period of time, it's effectively been watered down to next to nothing. So no, there have been. Is there? Yeah, I'll get you the 30 cases that define it.
So I'm sorry, go ahead.
Go ahead.
You had mentioned, just for clarity, that someone could be out on conditions of release for up to 2 years on a misdemeanor that only carries the sentence of up to 2 years.
Yeah.
But that I missed hear you when you said that also someone could be out on probation.
No, all I'm saying is they couldn't even be under our statutes. You couldn't be on unless very different, very specific types of cases, but you can't be on probation longer than 2 years. What if you pled on day one and your conditions were the same on probation as they were on conditions of release, you know, stay away from so-and-so or do whatever. You can't be on probation. You can be on conditions of release longer than you can be on probation. You could be in, you know, I mean, it's better obviously not to be in jail, but you're essentially serving time, you know, on conditions of release that much longer than you would if you know, there are 5, 6, 7-year-old misdemeanors that hang around out there because you think you haven't caught.
And I guess my third final question is, I know you still have a thing you want to go over is, I'm sure you're familiar, Senator Hershey and I sit on the Legislative Justice Oversight Committee, and we haven't got the results back yet from this pilot 3B project, which I'm sure you must be involved in.
That's what I was just talking about.
We're looking forward to getting the data from that, see that maybe other candidates could institute the same thing, because from what I hear, early reports are that's addressing some of the backlog cases, of 5 and more cases in the county. So I'm just curious.
There are stats that Jay Johnson brought to our correctional institutions. There's a PowerPoint that's available. It gives you how many cases were handled, how many were disposed, how many were mental health cases, how many were dismissed. You know, all of that stuff there's down on. None of which was surprising to me, because when you focus a bunch of new resources at a particular docket, you're going to get results from wherever you focus the resources on. When the resources go away, you go back to normal.
So preliminarily, I can't.
Preliminarily, yeah.
Does it appear that it is working?
Chittenden County, yeah.
Chittenden County. Okay.
I honestly, and I said this yesterday when I testified there, apparently BT Digger didn't want to wait around to hear from me until they read the article. But I'm not sure that it works in any other county. It, there's all the treatment resources you need, or at least the most that there are in Chittenden County. There's the lawyers in a compact space. There's a whole, we have 12 lawyers in the staff office there for the public defenders. So if I want to designate one or two to handle a particular docket, I can do it. If I, if it's, Lamoille County, I only have 2 lawyers. If it's Addison County, I got 1. The other ones, some of the other ones have 4 lawyers or 5 lawyers or whatever. And you can't take 20% of your staff out of the regular rotation to focus on the misdemeanor docket when they are loaded up with everything else, and the counties don't have the treatment resources. So it is the unique kind of economies of the scale of Chittenden County that allow that to be successful. It does show, however, that when you devote specific resources to a specific problem like this, you do actually get results. Don't fit in. Add resources to do more stuff. It's a good thing. And I don't say that mockingly, but it's just, I didn't expect it to be an abject failure by any stretch. We was going to get things done. Let me just tell you a couple of little things here, just because I know that. So on page 4, and this is in work. It's on page 4. It's line 7. Any period of delay resulting from the absence or unavailability of the defendant, that's fine, or an essential witness. I think it would say, or an essential defense witness. The absence of a state witness is one of the key reasons the case is dismissed as it is. Witnesses absent themselves for various reasons. Complaining witnesses recant. Witnesses are concerned about prior truthfulness of statements and like they disappear. Some just don't want the case to go forward. So maybe it's better said that the delay should not be counted if it is the result of an absent or unavailable defense witness. That would appropriately attribute the delay to the defense. That makes sense. Maybe it was written to try to get at that, but it just didn't say it. So that was one of kind of the technical things. The next thing I wanted to talk about is same page, line 16, sub 4. This sort of implicates statute of limitations issues, technically. So if a complaint is dismissed by the prosecution and subsequently a charge is filed for the same or related offense, any period of delay from the date the charge was dismissed to the date, that I was understanding that to be that delay would be attributed. That's not delay that you could attribute to the state. One of the things I could see a potential tactic of saying, oh, now we're 18 months into this. I'll just dismiss the case without prejudice. And then, a year later, I'll bring it back. And now we start the clock over again. I don't think that's cool. I think it's one of those things where don't put it in the hands of the state to be able to restart the clock by dismissing a case without prejudice. This was written a little bit, to me, it was a little bit confusing. Maybe it's a wordsmithing issue as much as anything. There's also, it can implicate statute of limitations issues. When does what's going, this one's a little bit, first a little confusing, but it also allows for kind of manipulation of the entire bill. I don't know that anybody's going to sit around thinking about some 2-year misdemeanor somewhere and going, usually once it's dismissed without prejudice, nobody's thinking about that again. Anyway, we got, 1,000 other cases to deal with. So, but this little area was something I was had concern over. I just want to make sure there's nothing else. I don't think there was anything else particular.
We got a couple of minutes left. I did have one more question. One of the issues that was raised by the state had to do with the workload that would be created on them. And mention defense being able to file a 2-sentence motion, and then the state having to file a significantly more substantial motion. And I'm trying to think of a way to make it a little more balanced. And one of the components that I'm thinking of is an analysis of any delays that have happened being the responsibility of the defense to lay out to show, in their initial motion that such and such incidents happened where we filed a motion to continue. Here's why it shouldn't restart the clock, or whatever the analysis may be. Do you have any thoughts on that issue?
Could be one way to do it. Another way I was thinking of is to do like you do in civil suspension for DUIs, where defense has to identify the issues. It's almost like a checkbox. So you can say like, and if you haven't raised the issue that gives rise to the speedy trial violation, then you then effectively waived it for purposes of that motion. It doesn't mean like down the road. And again, it's notwithstanding any other constitutional rights to speedy trial. And this is where it's really deep in the weeds for like the legislature, but I think to speak for some lawyers, the interplay between Rule 48 and speedy trial, they're not. Speedy trial is a different thing than Rule 48, but they look at very similar criteria. So someone can be disqualified from speedy trial dismissal, but you might get a 48B dismissal in the interest of justice, case being de minimis, and other factors that in the interest of justice would require that the case be dismissed. For me, for example, Senator Vygotsky, that is like the area where if filed, a court could on motion dismiss cases where a case has been on for 2 years on conditions of reasonable violations. So you have a misdemeanor or some lower end case that is, in the general scheme of things, de minimis, and the person's been on conditions with no violations for longer than their sentence would be. The interest of justice may require that that case be dismissed. There's been some progress in the particular judges in particular counties about that, but it hasn't been live. But I think the rule exists, and you agree with me that that's a potential area where, I mean, I don't know, I'm your lawyer, but
For like 5 minutes, you've got more knowledge.
yeah, well, all that means is I have 40 years of forgetting stuff. But the bottom line is that there is this interplay between the two. So all of these tools exist. We're just trying to hone in so that these things that we know exist and have some meaningful bite behind them again.
Last question, because we got the floor in a couple of minutes.
It sounds like too that we're looking at something like this as trying to apply them more universally and thus more justly. Do you feel like there would be more geographic justice with more of a direction of you shall use these tools?
Well, clearly it will make it so that, like I said, there are particular judges who have interest in these issues. So if you happen to be in that county and you file and this judge is there and you know that and you're gonna get interested. And then there are other judges who aren't. I mean, most of the judges now are like ex-prosecutors, so they aren't looking at things in the same way. Oddly enough, some of the ones who are the ex-prosecutors are the ones who look at these very carefully. I mean, I can't generalize, but it would clearly set a legislative intent and standard where they would have to work to get around it as opposed to, now rely very easily just on, the general idea that things aren't going to get dismissed no matter how long they sit there.
Well, thank you for coming in. This is very helpful.
No problem.
I've got some potential ideas to change this up a little bit and we continue to talk about.
Appreciate the
Thank you.
opportunity.
All right, we can go on.